Okay. Well, good morning, everybody. We still have some people signing on, so we'll give everyone a few minutes. Well, not too long because we have so much to cover. But I want to welcome everyone on the Arkansas ILG members. This was extended to the RSHRM State Council. And also my individual clients. So there was some crossover that some individuals were a member of both one way or the other. So we're real happy that everybody has joined us this morning, which, as Mike will say, this is probably an 8-hour conversation that will go for 90 minutes. With probably a ratio of 10 questions and to a ratio of 2, we know the answer. So the purpose of this program today is just to maybe clarify a few things, at least let us know where we are with this. It's an evolving, it changes almost every day. There's probably more seminars going in the hallways of law firms trying to figure this out in the hallways of HR, because really very few really know what's really going to happen on the Biden mandate and what Osha is doing as well. So I'm a big cat lover, have been for years, have 2 cats. So to me, this is probably a big hairball that we're trying to cough up. We'll see when we cough it up. We extend this to 90 minutes. There's a chat if you want to ask some questions. Let's see how many we have coming on. Well, we got 58. There was about, and it keeps going. We had about 75 or so that have registered for this. So we'll kick this off here in about 1 more minute to give everyone a chance to sign on, because I know Mike has worked real hard to put some context into some of this, but there's a lot of unknowns, but there are some things that are evolving. So at least you'll come up with some takeaways going forward. And we suspect that there's probably a lot of lawsuits just waiting for someone to hit the button when this thing comes rolling out. For those that are members of the Arkansas ILG, I'll just get 30 seconds about that. That's a focused nonprofit group of consultants, attorneys, HR professionals that are handling EEO within the organization. A lot of them is focused on affirmative action plan and OSCC compliance, and I'm honored to be the chair of the Arkansas ILG. So with that, I want to go ahead and kick this off and welcome everybody and introduce Mike Moore, who is a partner with Friday, Eldridge and Clark, heading up their labor and employment division, and focuses on litigation and discrimination areas, wage and hour, collective bargaining actions, sexual harassment, wrongful discharge, FMLA, the list goes on and on. He has been a frequent speaker at not only chapters and organizations to give of his time to help people understand this wide world of EEO law and OSCCP compliance and wage and hour. He's very deeply involved in the community. He's on the board of the Arkansas State Chamber of Commerce and is chair of the Unemployment Insurance Committee, and has been very deeply involved with a lot of the legislation that took place during this last year, representing employers and the HR profession as well. And has also been a graduate of the State Chamber Leadership Program as well, has chaired that and serves on several nonprofit boards. So the list goes on and on, as he's one of the best lawyers in America and Lawyer of the Year in 2018. So with that, we will turn it over to Mike Moore. Thank you, Mike, for doing this for us, and tell us about this hairball.
Thanks, Tim. Welcome, everybody. Happy to be with you all this morning. It's, we've been talking before we got started, and Tim calls it a hairball, and I'm a Seinfeld guy, and I say we're in the bizarro world. And frankly, the most I'm going to say to you today is I don't know. That's what I'm going to tell you on and on, because as Tim said, we've been our whole conversations here at our firm. We just walk away shaking our heads right now. I keep saying I'm tired of being a COVID lawyer. I just like to get back to being a regular sexual harassment and wage hour lawyer, but that doesn't look like it's going to happen anytime soon. And so we've been spending way more time than we want trying to figure out what all is coming down the pipe. I tell the story all the time. In April of 2020, I walked into Dan Harrington's office and said, Dan, this is like a semester of law school in 2 weeks. We are just getting flooded with stuff. And little did I know that was the tip of the iceberg. And so, we're going to talk mostly today about the Biden federal contractor laws or rules, but we're also going to talk about some other things. And so what we have now for everybody to kind of consider is, okay, so we have the federal contractor rules, which are vaccinate or go. We have the Osha ETS coming down the pipe, which is vaccinate or test. We have the healthcare, the CMS rules, which are coming down the pipe, which are vaccinate or go. And then we have the state statute, which is going to say vaccinate or test or have some jackleg doctor say you got antibodies. And so all of that is coming together at the same time, and it's all different. And wading through and deciding which of those 4 different things you may or may not be subject to is going to be difficult. And if the state statute stands, it's going to be in conflict with all the federal rules. The word on the street is that there'll be a lawsuit challenging the state law, challenging its constitutionality. But that won't be coming down for another month or 6 weeks, probably. My guess is there'll be lawsuits filed, as Tim mentioned, on all of the federal mandates. And the federal contract mandates, which we're going to talk about in a minute, will probably be challenged pretty soon. The OSHA will be challenged the moment the ETS is formalized. As I'm sure some of y'all seen, I read a news article last night that unions and business groups and everybody who gets an audience with the feds are begging them, do not do this before the first of the year, because you're gonna, like the trucking industry is screaming, we can't get enough drivers anyway. If you make us vaccinate our employees, they're gonna quit and nobody's going to have Christmas. Now, that may be the kind of approach that gets somebody at the federal government to say, wait, we just need to wait on this a little bit. The reality, y'all, I think, is that all of the threatened mandates are just getting people to, anybody who's on the fence, they're going to go ahead and get vaccinated. That's a good thing. The bad thing is the people that are not on the fence, but are on the I'm not getting vaccinated, they're now getting more polarized. So it is as I've said, it is the revolution of our time that might be happening in our society. Hopefully not, but everything's so politicized now, who knows? So what I tell you today, I may change my mind tomorrow. So y'all gotta keep up with it just like I am, because it's changed every day. We're all, as we've been doing for over 1.5 years now, we're all flying by the seat of our pants. Hopefully we'll get a little more clarity pretty soon. But let's go ahead, Tabitha, and get to the PowerPoint. We'll go through some of these different things we're going to be looking at.
And we'll be sending the slides out to everybody. I know that's always a question after this presentation, and it's also being recorded, so that can be available as well.
Right. Okay, Tabitha, will you share your screen?
Yeah, Mike, I was on that slide. Did it not show? Just give me 1 second.
Okay. Hey, and y'all, while we're doing that, you
We
got
might have to do a
comments?
little hybrid thing. So
Okay.
let me see if this works for you, Mike.
Hey, if y'all got comments or questions or experiences, put them in the chat. You can direct them directly at me or Tim or Tabitha, or just have it general, so that we can catch those as we go. So here's Tim and I have been working with each other for I don't know, almost 4 decades now. We've known each other, and so he's emailing me about what he thinks we ought to title this thing, and he emails me this: Hamlet in a pandemic, to mandate, vaccinate, test, or not to be, that is the question. And I responded, I can't believe that we are coming to this where I am thinking the exact same thing you are. It's just I'm a little less fancy, and so mine was to stick or not to stick. That is the question, and that's what we got going forward.
I can do it this way, Mike, if that works for you. I know it's a little distracting with this header, but I can't get it to work without.
I'll holler at you. Well, this is fine.
Okay.
Okay, so the new federal contractor rules say that contracting officers shall insert the COVID safety protocol clause in all solicitations, contracts, task orders, delivery orders, and modification thereof that are for services, including construction, performed in whole or in part within the United States, or its outlying areas. I don't even know what that means, but it is for solicitations issued after October 15th, or contracts or delivery orders awarded on November 14th from solicitations issued before October 15th. And so if you're trying to get a new contract and it meets these standards, this is going to be in it. Okay, go to the next one. Trying to define the contracts that are going to be subject to this. And I know we have a question in chat about particular coverage, and I'll get to that in just a minute. So this is all extensions and renewals after October 15th, options exercised after the 15th, and on existing indefinite quantity contracts that are anticipated to have orders that exceed the SAT, and the SAT being 250,000, and that have an ordering period that extends beyond October 15th. So I think my takeaway from that is, if you're going to get a new federal contract for services over $250,000, it's going to have this clause in it. All right, let's move to the next one. All right, so in the workforce task force says the guidelines say that contracting officers may insert the clause in solicitations issued prior, in contracts awarded before, and in solicitations, contracts, task orders, delivery orders that are valued at or below the SAT performed whole in part. So what we have is, if you got a contract above 250K, then it's going to be in there. And if you have a contract below 250K, your contracting officer can put it in there. And the way I look at it is that if a contracting officer knows they're being evaluated on how good they do in getting compliance with federal law, then they may well be inserting these clauses in a whole lot of contracts. We've been on, I don't know how many calls and Zoom calls and conferences the last 6 weeks about all this, and the conventional wisdom with lawyers that we talk to that do a whole lot of federal have clients that do a whole lot of federal contracting, are that these clauses are going to be inserted as going forward in virtually all federal contracts. The question, what if you just signed a contract renewal on 10/1? Then that is not subject to this, except in the discretionary area of this slide, where a contracting officer has the discretion to go back and insert it into the contract. We'll talk about what that might mean in just a second. All right, so Tabitha, I think back up. I'm sorry, I was reading something in chat real quick.
Can I answer a question real quick in the chat? It'll give me 2 seconds and I'll fix this screen. I know it's bothering everybody. Just give me 2 seconds. I'm gonna stop sharing and then you can answer whatever chat you need.
Okay. The one question is, are financial institutions covered by federal contract by these rules? And our opinion at this point in time is that simply being an FDIC financial institution is not sufficient to get you covered under these rules. There may be some contractual agreements that you might have with a federal agency, being a depositor for a federal agency, that might get you in there, but it is completely unclear right now. And as Tim and I were talking before we started, when there's also going to be some interesting ideas about whether you're going to be covered under the Osha ETS, and we'll get to that later in the program on the definition of what will be covered as a 100 employee.
Mike, I wanted to test that screen. Can you see the safer federal workforce screen?
Yes, ma'am. Yes, ma'am. That's where
Let
I
me
am.
see if it advance.
So
Go ahead. I'll fix it in just a second. Sorry about that.
okay, so the three main things that are in the Safer Federal Workforce Task Force guidance for federal contractors or subcontractors is that there's a COVID vaccine requirement for covered contractor employees, except in limited circumstances, and that would be medical or religious accommodation, compliance by covered contractor employees and visitors with masking and physical distancing guidance while in covered contractor workplaces, and designated the designation by covered contractors of a person to coordinate COVID workplace safety efforts at covered contractor workplaces. And so you see in there some terms that need some definition. And, you know, as I always say, when we got a lot of terms that have definitions that may not be absolutely clear, that's just something to make lawyers a lot of money. And I wish it wasn't. Like I said earlier, I wish I was doing wage hour law and not COVID law, but that's where we are. So another definition is community transmission, and that is the level of community transmission is set forth in the CDC COVID-19 data tracker county view. And so for those of you who have not availed yourself of that little resource, if you are the designated person to coordinate COVID-19 safety, you're going to need to. I am the, I guess, self-appointed by default coordinator of this workplace. And so I've been tracking that data tracker county view website every morning when I get to work and every afternoon when I leave to see, because we are now, Pulaski County at least, is no longer in a high transmission area, but is in a substantial transmission area. We are maybe a week to 10 days of being a moderate transmission area. And for those of us who have been following the CDC guidelines, we have been masking up when we're out in the hallway. And when we go from substantial to moderate on the COVID-19 data tracker county view, then we can take our mask off to walk down the hall. So it is something you all who are going to be the designated coordinators want to look at and keep track of for your county, to make sure that that you know when your rules change. So one of the terms in this that I've been particularly chuckling at the last week or two has been the contract and contract-like instrument. And I've talked to every lawyer on my hallway, and we've never heard the term contract-like instrument. To me, if it's a contract-like instrument, it's probably a contract. But you know, the way they like to write things when they're writing regulations is they like to think they're being extremely clear. What they end up doing then is muddying it up. And so they say now that it has this meaning set forth in the DOL's proposed rule on increasing the minimum wage for federal contractors. And they say, if the Department of Labor issues a final rule relating to that proposed rule, this term shall have the meaning set forth in that final rule. So we don't know. We have no idea what's going to happen at this point as far as that definition. And then interestingly, they say the contractor or subcontractor workplace location. And that means a location where a covered contractor employees work, including a covered contractor workplace or a federal workplace. Now, I'm going to talk in a minute that this is the one you need to stick on. This is the one you need to pay attention to, because this is the one that's going to make life very, very difficult for all of us who are in this spot. You know, we're trying to determine right now whether we're a federal contract subcontractor because of our advice to federal contractors. And it's not an absolute slam dunk that we're not. And so it may be that our subcontract, our contract with our clients is going to be a covered subcontract, which would subject us to that. Thank God that right now our firm is at, I think, 96% vaccinated. So we would be able to comply. So let's move to the next one. So a covered contractor employee, full-time or part-time employee working on or in connection with a covered contract or working at a covered contractor workplace. This includes employees of covered contractors who are not themselves working on or in connection with a covered contract. This one finally sunk into my brain, I believe. And let me tell you my thought process for over the last week or two in looking at this stuff is that I was thinking, okay, so if I've got somebody who's out there working on that job, let's just say I'm a heat and air contractor, and I've got a job at the Air Force Base that I'm sending my employees to. So I'm going to have to make sure that all the employees I send to the Air Force Base are vaccinated. Well, in looking at the first part of this definition, they then would be if they're not only working on, but if they're working in connection with, and that would be all of the home office support staff who would be working doing tasks in connection with the maintenance of that contract. And so it might have everybody from the accounting department, it might have the HR, might have a lot of people involved that would then be a covered contractor employee. But then it says, back up, then it says this includes employees of covered contractors who are not themselves working on or in connection with a covered contract, which means any employee of a covered contractor who is working at a covered contractor workplace is covered, which means if I'm doing a government contract, it means to me, we may see something different, but reading this tells me that if I have 1,000 employees and I have a federal contract that takes 100 employees, that I don't have to vaccinate 100, I have to vaccinate 1,000. Everybody has to be covered. Everybody has to be vaccinated. All right, let's move on now. So it says a covered contractor may be required to provide an accommodation to covered contractor employees who communicate to the covered contractor that they are not vaccinated because of a disability, which would include medical conditions, or because of a sincerely held religious belief, practice, or observance. So it says we have to follow Title VII to provide an accommodation. And I want to talk about the accommodation discussion for a second, but I want to say first, it's unclear to me, given the previous definition we just discussed, what accommodation you could make. I'm not sure that a contracting officer is going to let you send an unvaccinated employee to the federal work site. It may be that what they agree to is that you can segregate or send all of your unvaccinated employees to another job. That brings up all sorts of other interplay there. But the problem is that if I have here at my firm, if I've got an employee that's got an accommodation request, then we make that accommodation decision based upon our business needs and what we think we can reasonably accommodate. But in this context, we got to overlay the fact that we have a contracting officer of the federal government overseeing everything we do, who may not allow us to provide a certain accommodation. And that just is going to get us into all sorts of conflict situations. And what I'll be interested to do is to handle an EEOC charge where the accommodation my client wanted to make for an employee was not allowed by the federal agency. And then I'm sitting over there talking to Bill Cash at the EEOC saying, well, wait a minute, you guys wouldn't let my client do what we wanted to do. So how can we be held liable? It will be interesting. So back up, Tabitha, if you will, because I want to spend a few minutes on accommodation, because I keep getting questions on that, which I think need some attention generally. So I was doing a presentation yesterday and got a question about, do we need to ask our employees if they need an accommodation? And my answer is absolutely not. We do not need to solicit anything. This definition says, or this requirement says, that we may be required to provide an accommodation to an employee who communicates to us that they are not vaccinated because of a disability. So, and it says which would include medical conditions. And in this context, I don't look at it as a disability accommodation. I look at it as a medical condition accommodation, because the medical condition might not constitute a disability in and of itself, but in the context of receiving a COVID vaccination, it might. And then the one that we're really everybody is struggling with is the sincerely held religious belief, practice, or observance. And that is the one that's getting the most play in the vaccination area. I will say that, and I don't have it here with me, but the EEOC just came out with some new guidance on how you address a religious accommodation request. And my cursory review of it so far is that it's pretty good and pretty helpful. But there is a, because of the politicized nature of the vaccination issue, we have had a real overlay of political views cloaked as religious beliefs. And I'm really not trying to opine on anybody's sincerely held religious belief, but I just got to say I've seen a lot of them that are an accommodation request cloaked in religion, which are actually political objections. and I get it. People are polarized against. Some people are polarized against vaccinations, and they're sincere. They have a sincerely held belief that they don't want to get vaccinated, and I get that. But it sometimes it makes it hard to determine whether it's a religious belief or a political belief. And then we overlay. And so I know that the author of the most viral document in this context is on this call, so he can speak up. Oh, I don't know if Tabitha will let him unmute, but maybe he can put it in the chat. they authored a document that says if you have a sincerely held religious belief against the vaccination, do you also have a sincerely held religious belief against these 19 medicines that everybody takes every day because they were developed in a similar way? And I bet a whole lot of people are using that either formally or informally in responding to accommodation requests. I was on the phone with a lawyer the other day. Okay, so now that Richard has taken credit, thank you, Richard. Well done. And so I was talking with a lawyer the other day that's now in-house with a big construction company who used to work for us, and she moved to Omaha several years ago, and she said she's spending her next week going over accommodation requests. They got 2,000 of them that they got to go through, and having done it for several clients now, it is a tedious process. And the problem then is that in the decision of, okay, I've got this person who qualifies for a medical accommodation and this person who qualifies for a religious accommodation, then I have two standards of determining whether I've got an accommodation that I have to give. One, whether it's a reasonable accommodation, and one, whether it would cause me undue hardship. And those definitions are different. And one thing I will say, and it's been a real interesting process, is because many of us have had varying degrees of remote work over the last 18 months, then one of the continual accommodation requests is to continue to work remotely. And so that is a lot of my clients believe that their business runs a whole lot better if everybody's working in the same place. And I understand a lot of businesses have continued with the remote, but I tell people all the time, our firm went remote for 90 days, but my practice group all stayed here every day. And because our ability to brainstorm was crucial to surviving what we had to learn. So in the accommodation discussion, it is really important to determine, are we going to allow remote work to be an accommodation? And some of my clients have said, we are going back to an on-site workplace. We will allow you an accommodation to work remotely, but we are going to reevaluate that every 30 days. What I want y'all to hear is that the accommodation that you may offer to somebody for a medical or religious reason is not a permanent accommodation. Does not have to be a permanent accommodation. I don't think it ought to be a permanent accommodation. And I think you're well served by telling the employee, this may change. It could change at any time. Because as I've been saying, everything changes regularly. And so, that's the way I want to approach that accommodation issue, is that we'll give you a break for a little bit as we see how things go, and then we'll determine whether we need you. Because if we're having regular lunch meetings sitting in a conference room talking about what do we got to do about this, this, and this in our workplace, and you're at home, you're missing that. And so that may be that we may be able to, you may be able to marshal the evidence that you would need to respond to an EEOC charge saying that you refused a reasonable accommodation by saying, here's what happened. Here, we offered the accommodation, and here are the problems we had behind that that caused us to withdraw the offer of accommodation. All right, now we'll move to the next. Okay, so the rules give the out that should a federal agency have an urgent mission critical need for a covered contractor to have employees begin work on a covered contract or at a covered workplace before becoming fully vaccinated, the agency head may approve an exception. Notice it's not the contracting officer. So to me, this is not going to be something we can bank on getting any relief on. And it is only for a 60-day period that we get people that we say we got to have that extension, and then we have to ensure that they're complying with masking and physical distancing for the unvaccinated people in covered workplaces prior to their being vaccinated. Okay, go ahead. So then we have to ensure that all individuals, including covered contractor employees and visitors, comply with published CDC guidance for masking and physical distancing at a covered contractor workplace, which means everybody that comes in your office better be complying with masking and physical distancing, or you're in violation. I keep getting reports. I had one of my law partners I walked in with this morning, and she told me she was out at a couple of different businesses yesterday, and that nobody was wearing masks. And I think that that's in violation in Pulaski County, at least, of that published CDC guidance. And so that is the county data tracker that I talked about a little while ago that we got to keep in mind. And as long as that is substantial or high, we're gonna have to keep those masks on when we walk down the hall. That's the way I read that CDC guidance. So that means that I got to enforce that for all my visitors. And there's then, for another day, all the other problems with the governor's declaration of immunity if you're not following CDC guidance. Anytime you're not following CDC guidance, there's a whole lot of bad things that can happen. All right, so let's move on to the next one. So unvaxxed people got to wear a mask regardless of the level. And then what I was just talking about. So if they're unvaxxed, they should maintain a distance from at least 6 feet in conference rooms and any other communal workspace. All right. So I think this is this. Hang on just a second, Tabitha. Yeah, this goes back to the accommodation request. And so this is that we got to go and keep the data tracker county view for all of our workplaces. So if we got jobs all over the state, then we got to be checking every county where there's a job to determine what the proper safety protocols are at that work site, depending on what county it's in. I hadn't spent much time looking at other Arkansas counties, but I would suspect that there are very few Arkansas counties who are below the substantial rate, and so that's it's a cases per 100,000. There are two things, and so the one I'm looking at, and I don't have it here up in front of me, but it's cases per 100,000 population, and it has to be under 50 cases per 100,000 in order to drop below substantial transmission rate. We are now at 74.51. We were close to 100 10 days ago. There's 391,000 people in Pulaski County, I think. And so we're steadily tracking down. And so Tim's question is, does every state have a data tracker, only Arkansas? So yeah, on the CDC data tracker county view, there's a place where you can look in each state, and then for each county, and it's a drop down then which shows every county in each state. And so you can go directly to that county really quickly, and it gives you both the 7-day average, which is what we're looking for, and the percentage change in the last 7 days, which shows you the trend. And luckily we're trending down pretty quickly. And that's why I've got my fingers crossed that I can take this mask off next time I walk down the hall in the next week or 10 days. So, I'm about to move to a series of questions that have been asked to the federal government, but have not been answered. And I would ask, we are halfway through, and I would ask if it would be okay if we would break for 3 minutes and let me go get a little cup of water. So I'll quit choking while I'm trying to talk to you. So y'all hang tight. I'll be right back.
While Mike is, I was wondering if he was had some water handy. He was coughing quite a bit there. But if you have some questions, sure, put them in the chat. We will get to them as best we can. And Tabitha is monitoring those, so don't hesitate to put your questions in there. I know there's probably a lot of questions, and Mike's doing a good job here with, at least for me, from my standpoint, defining a few terms and some things that are pretty important. So anyway, I appreciate everybody that's been on the call. Give Mike a chance to get some water. So just hang tight, everybody, and think about your questions and put them in the chat. Every question is a good question. So let your thoughts be known. Or if you have any suggestions or situations you've run into that you could want to share with everybody, that would be good as well. So thank you very much for hanging in there. While Mike's coming back, we were talking earlier, and there are several on the call. Some are my clients and vice versa that are in the banking industry, and so this whole issue of these renewable clauses being inserted into clauses. Well, obviously banks don't have that situation, although they're covered by FDIC. Now, I think that OSHA may catch banks there, but it's going to end up being, what's defined as a workplace, because if it's over 100 employees, most branches don't have 100 employees, so we don't know what that's going to look like. What I find is curious is that I'm sure that FAQ has been, or that question has been posed, but in the FAQs I saw yesterday, that hasn't been answered. I don't know if they're afraid not to answer it or it's a slippery slope, but but that I suspect that question has been posed, but the government, I think, is avoiding the answer, at least they are today. Anyway, I was filling some time, Mike, so are you okay?
Thank you. Thank you. Yeah, I scratchy throat, wanted to hopefully I don't have the COVID, but just need to get something to wet my whistle a little bit. So question is how an employer and be able to know if employees are in compliance unless they wear some type of visual identifier as they move around facilities. Is it a HIPAA violation to require some type of identifier? A lot of people I know are making people wear wristbands. There are a lot of different ways to make sure they're vaccinated. We required everybody to present their vaccination card for inspection. We did not keep copies of vaccination cards because you can, but then you got to make sure you keep it in a separate medical file. But we had some people that texted them or emailed them, and then we deleted that, so we wouldn't have that record. But we have a list that gives us a master list of people who are vaccinated. In our workplace, we have not done the scarlet letter like I know some people have, but there's absolutely nothing keeping you from doing that. To having some badge or wristband that designates whether somebody's vaccinated or not. So back up one tab. There we go. So question number one is when we do contracts that are subject to this, are we gonna have adjustments to them to offset the cost of compliance? There's and I don't know. I kind of assume that if you get a new chance to bid on a federal contract, that you're going to have to include that cost in there, and everybody will have to do the same, including those costs. There are all sorts of potential costs that everybody's going to have to consider. And number one is the cost of getting people vaccinated, and the additional cost of what if I have to go recruit a bunch of new employees who are vaccinated? I'm going to have to pay them more than I've had to pay my current employees. Am I not going to have enough people to put on the job, and therefore it's going to take me longer to finish? And so I can't imagine all of the different permutations of cost increase that are going to be caused by this, but the folks that are starting to think about it, I think, see what's going on there. So can contractors refuse to accept the new clause in contracts that have just been modified and are not up for renewal or option? And I think the answer to that is yes, but the problem is that you may be reported as a non-cooperative contractor, and there's a big fear that while you may not be debarred, it will be you'll be blacklisted in some form or fashion. Will purchase orders placed under a master agreement constitute new contracts? I don't know, although the way I read it, it seems to say that's the intent. It clearly is, it would be something that a contracting officer would have the discretion to do. So then for federal contractors subject to Osha ETS, will anybody provide guidance on how to address the differing obligations and whether additional costs incurred in meeting both are chargeable to contracts? And frankly, I have absolutely no idea. I can't imagine many circumstances where I would have a federal contractor that would have a contract big enough to be subject to the federal contractor rules, who would not also be subject to what we believe the OSHA ETS would be. And therefore, it seems to me there wouldn't be a conflict there. You just got to vaccinate everybody. You don't have the testing option. Of course, there's going to be an argument down the road that the accommodation for people under the federal contractor rules should be testing. And frankly, the OSHA ETS putting testing as the drop back makes testing an accommodation for almost anybody who has privately made a vaccine mandate. The way I look at it is, because if the OSHA ETS says we require vaccination, but if you're not vaccinated, you're going to be safe if you get tested. Well, that means that my private company clients who aren't subject to OSHA ETS will be met with the argument that I don't want to get vaccinated and I should have the opportunity to get tested. And the federal government says that's a reasonable accommodation. So that's going to cause a problem. I got a question. So the Bureau of Prisons, I guess, Troy, will not accept an equitable adjustment concerning testing. You know, we won't have in a federal contract, there won't be an equitable adjustment for testing because presumably testing won't be the requirement, vaccination will be. But there are all sorts of potential cost issues on excuse me, on the testing, but even though it's on the vaccination, because even though it's free, then we also got to deal with what is there a cost to let people off to go get vaccinated? Is there the cost to let them off if they have a reaction to the vaccination? All those sorts of things. So I think we covered this earlier, is the provision of FDIC insurance treated as covered service. And all I can say is conventional wisdom today is that it's not. Let's go to the next one. Okay. So then the question we were just talking about, if we have increased costs, will they be entitled to an equitable adjustment? And you know, maybe, but maybe not. And it may be that is at the discretion of the contracting officer. Obviously, it would probably take into account how much that equitable adjustment would be. And the next question on this slide is the one that really gets me, and I think is really going to get a whole lot of people, because I suspect some of us saw the news week before last, I guess, at Southwest Airlines. They had quite a bad weekend because their union was squawking because they weren't negotiating over some of the effects of the mandatory vaccination requirement. And so there appeared to be a whole lot of Southwest pilots that were sick that weekend, and a whole lot of travelers that didn't like that. So the information that I have, I believe the conventional wisdom, and I believe the case law is that if you are mandated by the government to do something with respect to a contract that is covered by a collective bargaining agreement, you do not have to bargain with the union over compliance with that mandate. However, you do have an obligation to bargain with the union over the effects that compliance with that mandate causes to the wages, hours, working conditions of your employees. And that's where anybody subject to a collective bargaining agreement is going to be stuck in a big problem, is doing that negotiating, because we don't have time for that. These rules are coming down too fast and changing too much, too often, for us to be able to effectively bargain over what compliance with that mandate is going to do. So another question are independent contractors who are retained by the federal contractor who work on or in connection with a covered contract subject to the vaccine mandate. What if the independent contractor doesn't work on or in connection with a federal contract, but works in a covered contractor workplace? So for example, if I have several locations and I have one location, one workplace, which is covered by a federal contract. And for example, I have another office somewhere else that I'm opening up, and I hire a contractor, an IT contractor, to come in and set up my information system. Are they going to be covered by this? There's a significant likelihood that they would be. So if an employee is having difficulty scheduling their vaccination due to supply shortage, will they be able to work provided they have negative tests as they wait for the availability? We don't know about that. There's all these logistical questions are left to be answered. Okay, let's move to the next one. All right, so do we have to pay by time off for them to get vaccinated? If we pay it, or do we get the equitable adjustment? Recover from vaccination? How much time do we have to pay for? Is that on us or on the federal government? So these are all questions that are left to be answered. My guess is they're not going to be answered in ways that we're going to be real happy with. All right. So do existing standards for assessing religious accommodation apply? I think so, but it's a little bit up in the air. And so back to what we talked about a little bit ago, is that accommodation accommodating them by offering testing instead? And if so, is that going to be weekly? What kind of test is required? all those just day-to-day operational, how do we do this, that are left out there for later determination. Okay. My favorite, what accommodations will be made for federal contractors located in states with laws prohibiting vaccine mandates? I don't know. It depends on what the judge says in the lawsuit challenging the constitutionality of the state law in Arkansas. But if that law is not thrown out, we're going to have some people that are in a problem area. Luckily, we beat the law they tried to pass on the last day of the last extension of the last special session, which would have said that y'all couldn't even ask your employees whether they were vaccinated or not. That came remarkably close to passing, but did not. It actually would have made the law that we're currently under just a complete nullity, and who knows what the answer to this question is. But I guarantee you there are going to be a lot of lawyers standing in a lot of courtrooms over the next 90 days answering this question on this slide. Back up one, Tab. So can we be sued for firing employees who have exemptions from the vaccine mandate, but who cannot be accommodated? Somebody who has a sincerely held religious belief, somebody who has a valid medical condition would keep them from being vaccinated. And for example, we think we have for example, we could say, we will accommodate you by allowing you to get tested weekly. You get you bring us your test results every week and we'll accommodate that. But then the contracting officer says, nope, not good enough, can't do that. Then we don't have any accommodation left. You know, the only accommodation we would have would be, as Tyson Foods did, I think, was to put people on unpaid leave, and kind of a you got 30 days to decide thing, or go find another job. And you know, that's the last step that I would suggest as an accommodation for somebody to offer an employee who refuses vaccination before they terminate them. But the answer to the question is, I don't know. Okay. All right. So, can we offer remote work as a reasonable accommodation? And my belief, and I think it was on an earlier slide, but I'm not sure. These federal rules say that they cover any employee working, even if they're working from home, and even if they never come to the federal job site, which to me is the point number one for the lawsuit challenging the validity of these rules, because there's absolutely nothing about promoting public health and safety to say that an employee who sits at home and works all day and never leaves the house should be vaccinated. It may be for their safety, but it's not for the public safety. It's not for the safety of the federal workplace. So it appears to me that remote work is not an accommodation under federal contract rules. All right. So the question is, if an employee refuses to be vaccinated and does not qualify for exemption, will the contractor be required to move them from work on or in connection with the covered contract? I believe that's absolutely correct. But it's not clear yet. And if there's no other work, can the contractor fire the employee? I think that the answer to that is yes. And in fact, I think the answer to that is no contractor is going to have other work for an employee who refuses the vaccination, because the definition of a covered contractor employee includes all of their employees wherever they work. So then y'all, with a collective bargaining agreement, the union's going to grieve the employee being removed from the work site because you hadn't gone through progressive discipline. And so will that vaccine requirement supersede the collective bargaining agreement? Probably, but there's going to be a lawsuit to figure that out. And so the progressive discipline would be that the employee has failed to comply with testing requirements on multiple occasions or vaccination requirements on multiple occasions. And so towards the end of our hour and a half, we'll kind of get to the what should we do, and this is a place I think we can help. All right, so there's going to be a lawsuit and says these federal contractor rules are unconstitutional, or they are outside the authority of the executive department, or they're arbitrary and capricious, or whatever the grounds are for the lawsuit that's going to be filed. And there are probably going to be lawsuits filed all over the country. And so what happens when there's a court order saying, nope, federal government, you can't impose that requirement. It's not in effect. So if you then tell your contracting officer, it's not in effect, I'm not doing it, what happens when the appeals court reinstates it? I don't know. I wish I did, but I got to tell y'all, for any of y'all doing any government contracting, this is danger zone stuff. It will be a minefield of problems, because there are going to be conflicting court orders all over the country, and it's not going to get cleared up anytime soon. Hopefully it will get through pretty quick, but we're going to be sitting next summer still wondering about a whole bunch of this stuff, I would suspect. So who's going to back up one? Who's going to enforce it? Contracting officer, DOL, OSHA, wage hour division, OFCCP, somebody else? I don't know. Everybody's got a different spot in this. Everybody apparently has got a different view in this. Most of them have different requirements. So depending on which agency is enforcing it, there are going to be different enforcement mechanisms. And then you got, and then to add on this, I didn't put in here. So the NLRB is going to be involved when the unions start filing unfair labor practice charges about it. And so will there be monetary fines imposed? I don't know. We're going to be EEOC litigation. It will be really interesting. So far, at least my experience with the EEOC is that they have taken a hands-off approach to employers who are trying to have a vaccinated workforce. We've had several charges, and where people have been not granted an accommodation when they refuse to be vaccinated. And so far, the EEOC has not done anything to move those charges forward. I think we've gotten dismissal, notice of right to sue in each one of them. So hopefully that will stay in place, and we won't have the EEOC whipsawing us in this. So is a non-compliance going to impact a contracting agency's assessment of your ability to perform in the contract? Absolutely. It doesn't say that, but I think we all know that the more problems a contracting officer has with our compliance with the terms of the contract, the more difficult it's going to be for us going forward. So can they be subject to debarment? Not specifically stated, but that is the hammer they always have. All right. So will the contractor say we need to audit your vaccination compliance, your testing, or your accommodation records? How are they going to ensure we're not losing our confidentiality protection, and how are we going to make sure that we're not providing information outside of the scope of that protection? So then will disputes on enforcement be appealable? If so, to which agency? Who knows? I mean, the enforcement actions, which are going to continue for years to come, are then going to be appealable, and so those things will be going on long after I retire. So this is the question that was asked, and I think I know the answer. If an employee sues as a result of the vaccine mandate and wins, and the company now owes payments to that employee, will it be an allowable cost under the contract? And my guess is not. It will be interesting to see whether there's EPL coverage for those claims, and so I would encourage people who have EPL coverage to ask that question to make sure that it is a claim you can submit to insurance. If you don't have EPL, you need to get it. So then if they're if you got to defend yourself and provide your own legal counsel in a lawsuit, which you're going to have to, is that an equitable adjustment? And I think the same answer there, probably you're going to eat that. So more reason to get your EPL carrier on the phone and find out, okay, how are we going to need to adjust our insurance policy to make sure that we're covered for what we're going to have to deal with here. Okay, so so now I'm going to switch gears for a few minutes because I want to leave some time for questions. I know we've been getting a few, but y'all, if you got something, start asking questions now because we only got 14 minutes left. So now we talk about OSHA, and this is 100 or more employees to ensure their workplace is fully vaccinated, or require unvaccinated workers to produce negative test results. I'll tell y'all, this is what we did 60 days ago. This is the policy we instituted to have our people who are unvaccinated provide a weekly negative test result. It seems to be working pretty well, but this OSHA ETS is going to be a really interesting study in enforcement and in whether it's valid at all. Because as my partner Wayne Young and I were talking this morning, he said, so tell me how the OSHA can say that it's unsafe for me to work in an office with 100 employees without doing these things, but it's safe for me to work in an office with 99 employees doing these things. It is by definition arbitrary. And so we have not seen the new ETS. I think that there's, that's emergency temporary standard. And I think that there's a pretty fair argument that we've gone past the emergency spot now. But we'll see. There'll be a lot of different challenges. So Tim says, someone asked about the COVID pay, the tax credit ended 9/30. Should we still offer it for COVID related absences? I think our policy, and what I believe that the best practice is that if you have somebody who goes to get the vaccination and they say, I'm feeling bad, I need some time off, fine, go take it. It's paid time off, not counted against your paid time. A lot of people have instituted policies that say, if you go get vaccinated and you have a breakthrough case, then we will give you paid time off that you need for that will not count against your paid time off. We also might have a policy, some people do, which say, if you're not vaccinated and you get COVID, then you will not be paid for your time off, even if you have paid time off. And if you announce that policy before somebody gets sick, then they don't get that paid time off, unless you've got something in your handbook that guarantees it. But most people have a handbook that would allow you to change it. So you can change your policies to be a little bit more, I'll say, punitive against the people who don't get vaccinated. But what I'd rather do is say it is more a bigger benefit to those who do get vaccinated. All right, so the ETS is going to be issued probably in the next 2 weeks. Probably gonna have a December effective, something similar to the federal contractor guidelines, but I gotta tell you, the pressure being put on the administration right now to delay these things is substantial. And they may decide that the threat hanging over everybody's head will be sufficient to accomplish at least enough of the goal to delay implementation of it for a little while. That whole we're not going to have Christmas because there aren't going to be any truckers to carry toys around is an argument I think that might have some teeth to it. So what we think the OSHA ETS is going to say is that yeah, exactly, Gay. It's not I believe in my mind it's by definition not an emergency anymore. But we got to have proof of vaccination status, and that does not mean they have to give us their card, but it doesn't mean, in my mind, they have to show us their card. My guess is the way I would read this is to say if they have to submit proof of it, then OSHA might require us to show that proof, and therefore it might be best for us to go, instead of saying, show me your card, I'm checking your name on the list, to give me your card, I'm keeping it. Now, I don't know if any of y'all have had the experience with the counterfeit cards, but they're out there. I've seen one. I know somebody who has one. I don't I don't know. It's going to a lot of trouble to avoid a vaccination, but I won't get into that argument today. So a couple of questions real quick. If an employer who is a federal contractor can affirmatively determine that certain remote workers will never visit the location or come into contract with a covered contractor employee, are they required to be vaccinated? I believe so. I believe that the definition in the federal contractor requirements means that anybody who works for you in any location, including sitting in their bedroom all day, every day, is a covered employee. So we don't know how the OSHA mandate is going to get enforced, but we know that it will be, and we know that it will be costly, and we know that there's legislation been proposed to increase penalties, and so any of you who have been through many OSHA investigations know that it sometimes can be rather difficult. So someone asked, we still don't know yet if tests under 100 plus rules to be paid by company or employee, if over counter rapid tests will be allowed, correct? Yeah, we don't know any of that. We do know that in Arkansas, the company is required to pay for the tests because of the Arkansas state statutes on requiring medical tests of employees. You got to pay for it. The over-the-counter rapid tests may be allowed, but who knows? I've always been, my belief has been, since I've had to get tested early on and sat in my car for an hour and a half at UAMS ready to go through that drive-through, is that take-home tests where I stick a swab up my nose, I'm never going to stick that as far as the other person who did me that day in the UAMS drive-through. And so I've never trusted those as being accurate. But we'll see what they decide on that. All right, let's move forward. All right, so I think we're pretty close to the end, and we're pretty close to the end of time. And so I either missed a slide or the big issue on the OSHA mandate is who hell is covered? Because it's employee with 100 employees. Now, is that the FMLA decision, the definition of employees? Is that the Warren Act definition of employees? Is that the Title VII definition of employees? Because they're all different. Is it I got a workplace where, is it where I got 100 employees in one spot? Or is it I got 100 employees everywhere, but I may have 10 different workplaces and nobody over 15? To me, if we're going to talk about the sensical definition, it's going to be workplaces with over 100. Maybe they're trying to say over 100 because that's easier to absorb the cost. I don't know whether they're making that arbitrary decision, whether it's based on the absorption of the cost issue or it's the public workplace safety issue. We don't know. And so my guess is they're spending a lot of time up there in Washington trying to figure out how are we going to define this. And I got to tell you, it's going to make a huge difference in who is covered. The question about it, fake vaccination cards, is there any way to verify them when presented? I do not believe that there is a way to do it. I mean, you look at your vaccination card, it's just on cardstock. I can copy it on cardstock and write in whatever I want. There's no specific thing on there that I can't just plain old copy. So I think, what I would do is take the I-9 view of it kind of. So I'm going to look at this, and does this look like what I see in other ones? And if it looks funny, then what I might do is call the place where they allegedly got their shot and see whether they're on there. All right, next question. If we want to do a year-end bonus for those who are fully vaccinated, must we also provide to those who claim religious exemption? I'm a big believer, because of the amount of wage hour litigation that I'm involved in every day, that I want to figure out a way other than a non-discretionary bonus to handle this problem, because people are out there waiting for non-discretionary bonus lawsuit to file. And I really think that that's probably something I don't want to do. But the base question, if you give it to somebody who's getting the vaccination, do you have to get it somebody who claims the religious exemption? And I say no, that is not an accommodation. You don't have, the accommodation does not have to be given them that benefit. I can't tell you if there's any case law, but I know we discussed that in the hallway several weeks ago, and that was our conventional wisdom on it. So then the question, how much detail can we ask for to consider an exemption for medical reasons? Can we ask what condition and how the vaccine would negatively impact? Absolutely. This is not FMLA. This is ADA. And so I have with other clients engaged in direct correspondence with physicians saying, you say that they shouldn't get a vaccination for these reasons. What is the medical basis for this, given all of the medical information to the contrary? Because obviously, because of the politicized nature of this whole issue, there are a lot of people who are opining in ways that I was surprised about. And I know some doctors who have sincerely held beliefs against these vaccinations, and they're entitled to them, but they are by far the outliers. And given the amount of misinformation we're getting in this arena, we've been going back to doctors and being pretty strong, and there's nothing wrong with that. So what do we do right now with all of the uncertainty that we've got coming in the next 90 days? And I think really and truly, I'm encouraging all my clients to do everything we can to encourage vaccination, to discourage misinformation about it, to putting out all sorts of informational literature. And I mean, our weekly intra-company newsletter to our employees always has something about vaccination now. It is putting out, the Vaccinate Arkansas website has all sorts of great stuff on it. And so I'm trying to get people to do that, encourage your employees to get vaccinated, make it a peer pressure thing. You know, I said, as soon as you can put that needle in my arm, put it in there. I got my booster last week, and you know, and I tell everybody that I talk to, go get vaccinated. I'm proud that I'm vaccinated, and I think those of us that I think being loud about it helps. One interesting thing I will say, some of you may have seen this happen in your workplaces, is that we had a handful, maybe a few more than that, of employees who were really, really loudly complaining about having to get vaccinated. Didn't want to get vaccinated. Don't make me do that. Then when we instituted our policy that says you get vaccinated or you have to get tested weekly, and you have to tell us if you're vaccinated or not, so we decide whether you're in the weekly test group, we found out that several of those people who were the loudest about not getting vaccinated had been vaccinated. So I think we may end up finding that as we go forward. All right, I got us at 10:33, and I'm looking for other questions. I'll stay on as long as people want to ask questions.
Mike, I really want to thank you and Tabitha for putting this program together. As we stated up front, there's really more questions than answers, but I think that for the attendees today, the takeaway is that it brought to light certain elements and components and terminology that will help everybody in watching what happens when these mandates and the OSHA regulations come forward, that we will know certain things to be watching for that would impact our organization specifically. I also think that this is probably, I'm sure that we will probably have another program about this when that unfolds. That's probably a given. At least from my perspective, the OSHA mandate is one thing, but I think a couple of things that Biden has done that's going to be challenges that he didn't go through Federal Register or public comment for all this. So that's going to be challenged for sure. So anyway, the slides will be sent to everybody afterwards. As you can see on the screen, the HRCI and SHRM certification numbers are there for those that are certified. For the attorneys on the call, we have the form for the CLEs, and if you will email that, here's the form. We'll send the slides out, but if you will email Kathy Brand, who is on the board that I serve with, her email address is kbrand, BRAND, @axiom.com, and she will send that to you. I want to thank the Arkansas board who supported this topic. And again, Mike and Tabitha, thank you so much for doing this. With that, unless we have some burning questions in the chat, I don't think we do.
Thank you, guys.
Yeah, so Mike,
Wish I
thank
could
you
have seen
so
all the
much.
faces, but
Yeah, thank you so much, Mike. And if anyone has any specific questions, I'm sure there's Mike's email address. I'm sure he'd be happy to support any questions privately if you want to get in touch with him. And there's his phone number as well. So with that, Mike, thank you. Hope everybody has a great rest of the week.
Thank you, Tim.
Get vaxxed up. Look out for these regs, and hopefully we can figure out what and cough up this hairball eventually.
Good deal. Thank you, guys.
All right. Thanks, everybody. Have a great day.